Good morning, friends. Welcome to Gyan channel. In the series of our classes on journalism and mass communication and translation studies, today we will discuss about the problems of translation. In this, we will cover about all types of problems like phonetic, syntactic, structural, semantic, then efficiency of a translator, quality in translation and copyright issues. So let's begin the class. Firstly, we will discuss about problems of translation. Translators usually have to deal with six different problem areas in their work, whether they are translating technical documents or a sworn statement. These include lexical semantic problems, grammar, syntax, rhetoric, pragmatic, and cultural problems. So, firstly, let's discuss about lexical semantic problems. Lexical semantic problems can be resolved by consulting dictionaries, glossaries, terminology banks, and experts. These problems include terminology alternatives, neologisms, semantic gaps, contextual synonyms, and antonyms. These affect polysemic units. Synonyms and antonyms are only aimed at an acceptance which depends on the context to determine which meaning is correct. Next is semantic continuity, means a consistency procedure that works by identifying semantic features common to two or more terms and lexical networks. Next is grammatical problems. Grammatical problems include, for example, questions of temporality, aspectuality, means the appearance indicates how the process is represented or the state represented by the verb from the point of view of its development, as opposed to time itself. Pronouns and whether or not to make the subject pronoun explicit. Next is syntactic problems. Syntactic problems may originate in syntactic parallels, the direction of the passive voice, the focus, or even rhetorical figures of speech, such as a hyperbaton or an elaphora. Next is rhetorical problems. Rhetorical problems are related to the identification and recreation of figures of thought, means comparison, metaphor, metonymy, synecdoche, oxymoron, paradox, etc., and diction. Pragmatic problems. Pragmatic problems arise with the difference in the formal and informal modes of addressing, using you as well as idiomatic phrases, saying irony, humor, and sarcasm. These difficulties can also include other challenges. For example, in the translation of a marketing text from English into French, specifically with the translation of the personal pronoun you, the translator must decide whether the formal or the informal you is more appropriate, a decision which is not always clear. Cultural issues. Cultural issues may arise from differences between cultural references such as names of food, festivals, and cultural connotations in general. The translator will use language localization to correctly adapt the translation to the culture targeted. A very simple example is a financial translation which includes dates. If the text is in English, it is most likely but not absolutely certain that 5/6/2015 will mean June 5. However, as everyone knows, the same sequence in another language refers to May 6. Now, what are the efficiency of construction translators? The efficiency of translator depends on knowledge of language, research skills, communication skills, and individual subject specialization skills. If you want to see the quality in translation, then these three things are very appropriate to see. First is quality of target language, then is grammar, and lastly prose and objectives. The factors which affect the quality of translation are quality of source text, knowledge of translator, and proofreading. The problems of translation. There are certain problems, but these four are main. First is the structure of sentences, then idioms and expressions, compound words, and lastly translating the sarcasm. Now let's discuss about the translation and copyright issues. A copyright is a right granted to the creator of a work to protect it from unwarranted perpetrators and to make economic gains from such work. In India, a Copyright Act of 1957 provides such statutory right to the creators of original literary, artistic, musical, dramatic works, or films or sound recordings as per Section 13 of the Act. With grant of such right, the copyright holder has the exclusive say of for reproducing the work in any form, for issuing copies of the said work of public domain, to make any translations of the said work, or to license or transfer it by way of an assignment, etc. In addition to the aforementioned rights, owner of the copyright also has a right to seek remedies in case of any infringement of his or her rights, that is, either civil remedies in the nature of injunction or damages, or can get the perpetrators punished with an imprisonment for a period of 6 months to 3 years, along with a fine ranging between 50,000 rupees to 2 lakh rupees. Thus, it is also important to understand if the same rights and protections are available to a translator with respect to his or her translated work. Now let's discuss about the meaning of a translated word. As per the definition given in Black's Law Dictionary, a translation is the reproduction of one language of a book, document, or speech delivered in another language. In simple words, a translated work is conversion of written material from one language to another language, while retaining the essence of the original text as closely as possible. In this backdrop, two situations can arise, wherein one instance the translated work is a mere replica of the original work into some other language, and in another instance it is more than a conversion of the original work into another language with a flavor of creativity added to it. Now, the question that arises here is under which situation can a translator be able to claim a copyright for the translated work? The copyright in translated work. If the author of the original book itself is a translator, this situation might not arise. But when some other person has either obtained a license from the author of the book or work or from the appellate board, then this situation could crop up. Before 2007, the criterion for grant of a copyright was based on the suite of the Bro theory. Applying to this theory, it can be said that even the translated work has originality, time, and effort put in by the translator, and so much work can claim a copyright. Let's discuss about the case. In the case of Blackwood and Sons Limited and others versus A.N. Parasuraman and others, it was observed that the right to copyright in the translation is not dependent on the terms of Section 4, but it springs from the very terms of Section 1 of the Copyright Act 1911, because the translation itself would be an original literary work. Further, in the case of Hafiz versus Abdurrahman Makhdumi, it was noted that even in the translation where brain labor and skill have been used, or where some literary works are carried out, the person who did the said work in the translation is the author having copyright over the same. This implies that a copyright subsists even in a translated work which is considered as an original literary work. Still, the question remains about certain translated works, such as literal translations from one language to another language. This question was adequately answered way back in the case of Macmillan and Company versus K and J Cooper. The code in this case said that in all cases where the reprint with the text of it considered merely of a reprint of passages selected from the work of any author would never have a copyright. In spite of reliance being made on the sweat of the brow theory, the courts were still conscious enough not to grant such copyright for mere translations so as to maintain the sanctity. But with the judgment of the Supreme Court in the case of Eastern Book Company and others versus D.B. Modak and others, the sweat and brow theory is replaced with the modicum of creativity theory, as per which a work should have creativity to be able to get a copyright. Thus, it was held in this case that novelty or innovation or innovative idea is not the requirement for protection of copyright, but it does require minimum degree of creativity. Applying the said principle in the case of the Bhakti Vedanta Book Trust versus Thomson Press India Limited, an interim injunction was granted in favor of plaintiffs, holding that the plaintiffs hold the copyright in the work in question, a translation of the Bhagavad Gita under the elite Srimad Bhagavatam. Now, the recommendations and final conclusion will be that though there is no direct provision in India under the Copyright Act of 1957, considering the cases decided as of today, a translated work enjoys copyright protection if it has a minimal flavor of creativity as against the presence of skill and labor alone. It is to be highlighted that as per Article 2.3 of the Berne Convention, even a translated work is eligible to get a copyright. While India is a signatory of Berne Convention, still there has been no effect given to the provision as per which translated works are to be protected as original works. Thus, it is recommended that suitable amendment be made in accordance with the said provision. With this, we come to today's end of today's class. Thank you. Have a very nice day. Let's meet in next class again.